Let's start. Welcome, everybody, and thank you for joining us today as we talk about the essentials of estate planning. So our presenter today is attorney Cathleen Summers. Cathleen co-founded the firm about 20 years ago with her husband and partner, attorney Phil Summers. Cathleen is a nurse attorney with over 30 years experience. Her nursing background gives her a unique perspective and behind-the-scenes knowledge, making her the go-to expert for our clients and their families when they're navigating the legal and healthcare worlds in a crisis. So Kathleen, I am going to pass it on over to you.
Wonderful. And thank you all very much for joining us today. And again, for bearing with us as we're doing this for the first time with Facebook Live. And for those of you who are on Facebook, again, thanks for joining us. So estate planning basics is really what we're going to talk about today. And when we talk about estate planning, it's really interesting. Oftentimes people will say to me, well, one of two things. Either I don't really have an estate, so why do I have to plan? And what is exactly in someone's estate that we're talking about for planning purposes? And how I like to respond to that is really, quite frankly, anyone over the age of 18 should really think about putting in these essential estate planning documents. And you don't have to have a large estate to be able to do estate planning, because it's more than just talking about what to do with assets that you may own upon your death. A lot of estate planning actually has to do with how to make sure that you maintain control, that you've been able to identify the people you want in important positions while you're still alive, but should you in any way not be able to manage things for yourself. So why don't we go ahead and talk about that question that always comes up, which is really, what is my estate and why do I have to do any kind of planning? Well, when we're talking about what your estate is, certainly we're looking at your asset holdings. So if you own property, if you have bank accounts or investment accounts of any type, if you have retirement accounts, things like life insurance and the value of those life insurance policies are all part of what we include in terms of the definition of your estate. But it's also bigger than that. Things like pets, if you own pets, and how do you deal with your pets upon your passing, or if you become incompetent or incapacitated for any reason. We also want to talk about what happens with your children, particularly if you have minor children. An estate plan is critical in order to be able to ensure that they're properly taken care of should something happen to you, either death or your inability to be able to manage things for yourself. So estate planning absolutely addresses assets and how we pass on assets and how we go about managing assets during your lifetime if you're not able to manage yourself. But it also talks about other things like your pets, like your children, what happens to them should something happen to you. So estate planning is absolutely critical to talk about control, not only for after your death, but also during your life, if control is no longer something that you're able to manage for yourself. So let's kind of talk first, just in general, about goals that people should be thinking about in terms of their estate plan. Estate plans can do many things. They can talk to us about how you want to pass on your assets after your death. They can talk about what's important to you in terms of your beneficiaries and how you want them to benefit from your overall estate. It also can talk about things during your lifetime, such as what are your healthcare wishes and how do you want healthcare decisions made for you or on your behalf should you be unable to manage those healthcare decisions for yourself. What's important to you in terms of the parameters of decision making? How do you want your finances handled and who do you want to handle those finances, again, while you're alive, but if you can't manage them for yourself? How do you protect your children? How do you protect other people who may be important to you, whether it be, siblings, good friends, charitable organizations that you may want to provide for? All of these kinds of things can be addressed in an essential estate plan and really should be part of the overall conversation as you're putting your estate plan together. We also can do some more advanced things where appropriate. If your estate is potentially subject to things like estate taxes in the future, we want to be able to minimize those potentially where we're able. We also may want to look to avoid things like probate, and I'll talk a little bit more about that process. That's more advanced planning and the use of things like trusts, but it is all part of the overall view of estate planning and how you want things to be managed. We want to talk about passing on values. It's interesting. In a well-done estate plan, you can actually, talk about what's important to you. How do you go about maybe taking on care of the next generation, whether it be, again, your children, nieces and nephews that you have, and forward from there, maybe grandchildren, maybe other individuals that you want to provide for. And you can provide for them in many ways, through direct gifts to them, through the creation of ongoing trusts for them that will hold money and manage those monies for them. And so all of these kinds of questions and concerns really should be looked at as you're putting your estate plan together. So what are really the components of an essential estate plan? There are really 5 documents that we recommend everybody consider putting in place. Again, regardless of your circumstances, if you're 18 years of age or older. Because remember, we talk a lot with people who have these young adult children. Now that a child is 18, you no longer are able to step into their shoes and manage decision-making for them. You can't make their healthcare decisions for them any longer. You can't just step into their shoes to manage their finances. So they too have to think about some of these important documents, even if they haven't yet amassed what we would consider to be a significant amount of assets that they have to worry about passing on. So let's start really with the last will and testament, because oftentimes that's the cornerstone of an essential estate plan. I like to think of that last will and testament as an instruction sheet. It really tells us what you want to have done with assets that you own individually when you pass away. So remember, assets that you own with someone else, as long as there is a right of survivorship, will pass to that survivor without having to do anything upon your death. Assets that have named beneficiaries, like retirement plans and oftentimes life insurance policies, will also pass to those named beneficiaries without having to do anything other than usually claim forms that go with the financial institutions. But the will is really going to take care of things that you own individually. If you have a bank account, if you own property, we don't know what to do with those assets after your death. And the will is going to provide us those instructions. So it's going to tell us who's going to benefit from your estate. Who do you want to have taken care of with your estate assets? It's also going to tell us how you want or who you want to control that process. That used to be called an executor. We now call it a personal representative, but it's really the same thing. And this is the person who's going to be responsible for managing your estate after your death. If there is a will, and again, we highly recommend that a will be in place, then the will after death gets presented to the probate court. The probate court is asked to authenticate that will as your last will and testament and to give authority to the person that you've named as your personal representative. If you don't have a will in place, then the laws of the Commonwealth of Massachusetts will dictate how your assets will be distributed after your death. And it will also dictate who has priority to be named as the personal representative. You won't be controlling who that person is. Now, sometimes the results can be the same, whether you have a will or whether you die what we call intestate, without a will. But without a will, you have given up control over clearly identifying who you want to be your beneficiaries and who you want to be responsible for managing the estate after your death. And so, critical document to put in place to ensure that your wishes are known and followed after your death. The rest of the documents that I'm going to talk about are really documents that come into play while you're still alive. So remember, a will only becomes effective after your death, and it only manages assets and it tells us what to do with those assets after your death. You have the ability to change the terms of that will at any time, as long as you're competent to do so up until the time of your death. But these rest of these documents I'm going to talk about actually manage things or help to identify who's going to manage things should you become incompetent or incapacitated. The first document, and it's a critical one, is called a durable power of attorney. This is a very broad-based document that provides a lot of authority to a person of your choosing to step into your shoes to manage all decision-making except for healthcare. It's really a financial tool. A lot of the authority that's given in the document is talking about how to manage your assets, pay your bills, make decisions about things even like beneficiaries of retirement accounts, life insurance policies. Potentially a power of attorney can make changes to trust documents that you may have. We give them a lot of authority to be able to act on your behalf. Now, why do we do this? Why do we give kind of this blank authority to somebody, carte blanche, to do as they believe appropriate? Well, two reasons. Number one, first of all, we don't know the types of things that your attorney, in fact, that's what we call the person who's acting on your behalf under a power of attorney. We don't know the types of things that they may be facing. We don't know if you become incompetent or incapacitated, if you're going to own assets that may involve stock and need to have proxy votes handled for you. We need to make sure your attorney, in fact, can handle your retirement plans, be able to speak on your behalf, make distributions if it's appropriate, pay your bills, do all of the things that you would otherwise do. The other thing to know about a durable power of attorney is that the person that you've asked to be your attorney, in fact, has a fiduciary responsibility to you. That means that they are supposed to be acting in your stead and in your shoes, and as if you were acting yourself. And so it's critical to choose someone that you have full confidence in terms of their ability to make decisions that are in your best interest, should you not be able to make these decisions for yourself. So it is a very powerful document. It gives a lot of authority to someone of your choosing to be able to manage things, should you not be able to manage your own affairs. Now, if we don't have a power of attorney in place and someone loses their ability, either they become incompetent or they become incapacitated for some reason and they no longer can manage their day-to-day activities and decision-making around their finances, then we need to turn to a court and we need to go through what is called a conservatorship proceeding. This is where a court gets involved. They actually approve someone being appointed as your conservator. You don't have control over who that would be. For instance, I oftentimes get appointed by the courts to be a person's conservator. And the issues are that this person is now incompetent or incapacitated. They've been adjudicated by the courts as so. And I'm now having to step into their shoes to make decisions about their financial life in particular. And I don't know this person. And I have no background about this person except for what I've been able to glean from court documents and sometimes from people who may be around the individual. But if I'm being appointed in this position, it often means that the person did not have close people, friends, family who would step into that role. And I'm now making decisions in a vacuum in terms of what this person might otherwise want to have happen. Where if you put a power of attorney in place and you name someone of your choosing who you trust and who you've had conversations with about what your wishes look like, then you've been able to control who would be in that position managing your affairs for you. So powers of attorney are powerful documents. but they're critical documents because you don't want to end up in a situation in which a stranger is stepping in and managing your affairs without any kind of parameters about what you would want and how you would want things to be taken care of. Now, one thing to know about a power of attorney is it is only effective while you're alive. So upon your death, the power of attorney will cease to have authority, and now we go to the will to find out who you have named next to step into the role of taking care of your estate. It can be the same person if you choose to, or it can be different people. But you, again, the issue is, or the thing that you need to remember is that you have control over these documents and who goes into these important positions for you. The rest of the documents that I'm going to talk about really have to do with healthcare decision-making. So power of attorney is everything but healthcare, really a financial tool. And now we're in the healthcare world. And the first document is a healthcare proxy. Healthcare proxies are really specific to Massachusetts. We in Massachusetts actually want to name a person to make a decision, should you be unable to do so for yourself with respect to your healthcare. Other states have things like advanced directives, medical directives, those kinds of things, which tend to be more of a written document that talks about specific wishes, that actually outlines your wishes with respect to healthcare. In Massachusetts, our healthcare proxy is just a document that gives authority to someone of your choosing to make a wide range of healthcare decisions for you, only in the event that you become incompetent or incapacitated. So remember, if you can make your own healthcare decisions and you're competent to do so, then yours are the ones that are followed. The proxy is only activated when you become incompetent or incapacitated. And the document allows you to name someone to step into your shoes to really be able to manage all healthcare related decisions for you. But again, it is only a document that provides authority. So it gives a very broad range of authority. It talks about everything from being able to admit someone to a skilled nursing facility if appropriate, or to a psychiatric facility if appropriate, to be able to authorize the use of things like antipsychotic medications if appropriate, or end-of-life decision-making if appropriate. So all of these authorities are in the document. And one thing you need to remember is that you need to have a conversation with whoever you've asked to be in this position so that they understand the framework of decision-making for you. What's important to you with respect to healthcare? Are you someone who would want extraordinary measures? Or are you someone who says, no, I do not want extraordinary measures, or I want them under these circumstances and maybe not these? I have to laugh a little bit. My father-in-law is one who always said, I don't want to have extraordinary measures, meaning I don't want to be kept on a ventilator. However, give it 72 hours. I don't want you pulling that plug too quickly. So these are the kinds of conversations that you want to make sure that you're having with the person that you've asked to be your healthcare proxy, so that they understand what the parameters are for decision-making should they have to step into your shoes. It's also a great gift to give your healthcare proxy, because the worst position to be in for someone who is acting as a proxy is to be in the position of having to make specifically end-of-life decision-making for someone and not having had any parameters or discussions with that person beforehand in order to make sure that they're really making the decisions as if the person were making them themselves. Now, what happens if we don't have a healthcare proxy in place? Well, in this case, we would have to go to a court and get a guardian appointed. And like the conservator, a guardian is a court proceeding in which you now have a court involved in appointing someone to be in this guardianship position to make decisions for you. And again, you oftentimes end up with a total stranger who is making the decisions for you and has no idea of you, of what's important to you, and what the parameters or the framework of decision-making really should be on your behalf. So healthcare proxies like powers of attorney are critical because it affects your life while you're alive, and it ensures that the people you want to be in those important decision-making positions are there. Now, two more healthcare related documents. One is a living will. Now, I had said that the healthcare proxy is a document that provides only authority. It doesn't really give us any specifics about what's important to you. A living will is a document that is more specific about what you would or would not want to have done with respect to healthcare decision-making. Most times living wills talk about wanting your healthcare needs met, wanting to be kept comfortable, but not wanting extraordinary measures. Now, living wills are actually not binding here in Massachusetts. They are not a legally binding document. We don't go to a document, we go to a person to make those healthcare decisions. But they can provide support to your healthcare proxy, particularly around end-of-life decision-making, and give them a little bit more written framework about what you would or would not want to have done. Another document that we oftentimes see people use is something called the 5 Wishes. That is something you can find, quite frankly, on the internet. This is more of an interview kind of document in which you go through and answer questions about what is and is not important to you with respect to healthcare decision-making. And again, it's a desire to give your proxy a little bit more framework that they can work with should they have to step into your shoes. So having those conversations with your proxy, providing them where you're able some written framework can be really helpful to them. But remember, the documents themselves aren't going to control the decisions. It's the person or the proxy who will control the decisions. And the last healthcare related document that we put in place is called the HIPAA authorization and release form. HIPAA is the privacy law that went into play in the early 2000s. And this is where a document where you're giving permission to your healthcare providers to be able to share personal information with the group of people that you have identified. So most definitely, we want to make sure the people you've asked to be your healthcare proxies are listed on your HIPAA authorization and release form. But you may have a larger group of people. Let's say you have a spouse and you have 3 children. You may have asked your spouse and one of your children to be your healthcare proxy. But you may want to ensure that your other 2 children also have the ability to speak with your healthcare providers about your situation, kind of to avoid that game of phone tag that we used to hear, in which someone would hear something and by the time it got to the end of the phone chain, it wasn't the same information. So this allows everybody to be on the same page, to be able to have conversations with the healthcare providers. They are not all decision makers. Remember, only those listed on your proxy are decision makers, but it does allow the people you want to be part of the conversation regarding your care and regarding your wishes. So really, the important things about estate planning and the things to remember is that it is really something that everyone who is an adult over the age of 18 should think about, should have in place. We do want to make sure that not only your wishes after you have passed away are being listened to and taken care of, but that we're also paying attention to what is important to you while you're still alive, and that you've identified the people you want in those important fiduciary positions for you. And we also do have other ebooks on our website, in particular one about trusts and whether trusts work. I didn't really talk about that today because I don't consider that really to be part of the essential package, but whether a trust is something that would work for you and your family as you're looking at your overall estate plan.
Kathleen, there is one that came in. Is tax planning part of estate planning?
It absolutely is part of estate planning. I would consider it to be part of more of an enhanced estate plan. Really today focusing on more of the essential aspect of things, but absolutely when you're reviewing your estate with your attorney, you do want to make sure that tax issues and complications have been addressed. There are ways, for instance, for us to be able to help reduce estate tax exposure when we're dealing with a married couple. Massachusetts has an estate tax a limit of $1 million, meaning that once an estate's value goes over $1 million, everything in the estate is potentially exposed to the estate tax. So when we're working with a married couple, there's oftentimes things we can do to help reduce that estate tax exposure on the second to die. When we're working with an individual, there may be other strategies that we can look at that would help to reduce estate tax exposure in the overall plan for that person. But it often involves the use of things like trust work or things like charitable giving and gifting.
And if kids live out of state, do they need to use an attorney in that state instead of Mass?
So we really do recommend that you utilize an attorney in the state in which the individual resides, because that is really going to be what controls. Now, if we're talking about a child who is in college, let's say, so they live here, their residence really is here in Massachusetts, and they are just living temporarily, although it feels sometimes like it's more than that when they're away at school, in the other state. Certainly, Massachusetts documents, as well as documents from other states, are recognized by each of the states, but it can cause a little bit of issue, particularly around healthcare decision-making, let's say, because we have a proxy, which is very different than written documentation about what someone does and does not want to have done. So where the person resides, that's where they should be seeking their legal advice.
And when can you override a power of attorney?
So remember, if you're the person so you're what we call the principal, you're the person who has created the power of attorney and you're naming someone else to act on your behalf, you always have the authority to be able to manage your own affairs as long as you're competent and capable of doing so. So the person that you've named as your attorney, in fact, under the document, doesn't have the ability to override your decisions as long as you're competent and capable when you put those decisions in place. You always have the ability to revoke or change any of these documents that we talked about. So even with the power of attorney, if you've asked somebody to be in that important position and you then change your mind, you always have the ability to amend the document and change who you've appointed or revoke the document completely. But remember that you need to make sure that if the power of attorney has been used at all, meaning it's been given to some of your financial institutions, that you make sure that they're updated and that they know that you've made this change to who you've asked to be in that important position. Well, I hope this was helpful to everybody. Thank you for participating in our first Facebook Live, and we really do appreciate it.